Hi, folks. It's Mark Merrill with Firm. On our program this time around, it's about freedoms and Maine Bill LD-2150 versus citizens. Now, LD-2150 has a long title to it, folks. And we posted up here a copy from the Legislative Council that takes care of all of the scheduling for the different committees throughout the Maine legislature. This is the Judiciary Committee for the past week that ended back on January 30th. But LD-2150 is a bone of contention. Here we go. An act to establish procedures for restricting access to state property, access to state services, and communication with or through state entities. Sure. Why not? Can this title be any longer? So we're going to get to it right off the bat here, folks. We do have a representative who spoke to the hosts of the GHRT program on WVOM radio recently. We'll have her input on it since she is a co-sponsor of this bill. But basically, here it is, folks. It was introduced back on January 7th and referred to the Judiciary Committee on the same day. No report yet from the committee as after a public hearing took place, which we'll get to. The sponsors are Senator Nicole Grohosky, Democrat of Hancock, and House Representative Rachel Henderson, who you'll hear from, a Republican from Rumford, and several other Democrats and independent members. Now, keep in mind here, folks, and Ms. Henderson brings this up. We'll make this brief comment from Firm's point of view. She's the only Republican on the whole sponsor of this bill, which seems to be about 7 of them. Doesn't sound very fair, does it? The purpose and scope is, though, folks, it would restrict access to state property and state services, to get to the point, limit communication with or through state entities, and apply these restrictions under Maine's harassment laws if, and I put quotations about that one, folks, apply the restrictions under Maine's harassment laws if an agency deems a person too confrontational. Now, why does this language even have to be put in there? I question that myself to begin with. Jeez. Key provisions: 90-day access ban. A state entity could issue a restriction for up to 90 days without a formal harassment complaint, then require a complaint to continue the ban. A burden of proof shifts to the citizen to contest the restriction rather than the state to prove harassment. The scope of state entity includes any office, any department, any agency, any authority, any commission, any board, any institution, hospital, or other instrumentality of the state. What? WTF, by the way. Controversy? Controversy? Really? Proponents argue it's necessary for public safety in volatile socio-political climates. Who came up with these words anyway? Philosophy professor? Probably leans to the left, too. Let's try that one again, shall we? Just for the heck of it. If you're just tuning in, folks, this is Mark Merrill with Firm, Fairness in Reporting Media, on freedoms, proposed Maine bill LD-2150. Make sure you know that one. LD-2150 versus our citizens. So proponents argue it's necessary for public safety in volatile socio-political climates, allowing preemptive protection of state facilities and personnel. Critics, including the Maine Police Institute, Policy Institute, let's try that again. Critics, including the Maine Policy Institute, warn it undermines the First Amendment. There's a red flag. Violates due process and could be used to silence journalists or other citizens without trial. Now, opponents note it grafts harassment law designed for private individuals onto the state, which cannot claim fear or emotional distress in the same way. Heaven forbid. This bill is part of a broader legislative conversation about balancing public safety and individual rights. Supporters see it as a tool to address threats to state property and services, while opponents fear it could enable overly broad restrictions without judicial oversight. And there's more of a page to come here, folks, and we'll get to that in a few moments. As a matter of fact, it does come under a link to the legislature. And we could certainly provide that in our comments and notes afterwards, folks. But it is, to at least bring it out and mention it, legislature.maine.gov/legis/bills. So that's where you would find it on the summary, and find LD-2150 as well. Now, we'll have a brief summary we'll get to right at this moment. We just wanted to mention that the way you can find it on the link through the legislature.maine.gov/legis/bills. legislature.maine.gov/legis/bills. Okay. Here we go. The summary, folks, as we have it here from the Legislative Council. The bill prohibits an entity of the state from restricting a person's access to state property or services provided by the state, or restricting a person from communicating with or through the entity for a period of more than 90 days unless certain conditions are met. It requires an entity of the state to include on a notice or communication restricting a person's access or communication the factual basis for the entity's decision. The bill requires an entity of the state seeking to extend or renew a restriction issued by notice or communication for more than 90 days to file through the Department of Public Safety, Bureau of State Police, a complaint for protection from harassment, and provide evidence to the court of the original notice or communication restricting the person from accessing state property or services provided by the state, or restricting the person from communicating with or through the entity along with the factual basis for the entity's original decision. That's just half the summary, folks. I mean, huh? All right. Now maybe, folks, as we move along here, we can probably find out a little bit more information here from the state representative we were telling you about. And her name is Rachel Henderson. She's one of the co-sponsors of LD-2150. She explains, coming right up here, what this bill means for overall Maine public citizens, Fort Kent to Kittery, and, as we say, Freiburg to Lubeck, and this right here. for First Amendment freedom of information as well. Here's Ms. Henderson.
I think the important way to view this is to look at what the current statutory landscape is, and then what this issue is trying to address. So currently, in the state of Maine, there is no real framework for state entities on how long they can restrict a person's access to public buildings. Right now, the current standard is, and we learned this yesterday from the state police, so we actually had the public hearing on it yesterday, is that a state entity can simply issue a no trespass warrant. So they can tell someone, for whatever reason, we don't want you here. Reach out to the state police. The state police have to look at two pieces of criteria. One is was that person actually on the property after they were asked to leave? And two, is the reasons for them leaving, quote unquote, justified? And without getting too deep into the lawyer talk on what is and isn't justified, it's simply the state police determining whether or not that person should be trespassed. And then that trespass order is in effect for a full year, which means a taxpayer doesn't have access to taxpayer-funded property. What this bill seeks to address is to put some real limits on how long somebody can be restricted from a public building. This bill would put a 90-day limit on that. Second, it would require that the state entity tell the person why they're being restricted from the property. And they have to provide that in writing. And third, if they want to extend it past that 90 days, they have to file an official complaint with the state police, and then that complaint has to go to an actual judicial hearing. And that hearing would be an opportunity for the person being restricted to be heard. There would be grounds there for them to quote-unquote, plead their case. So right now there is no process for that. It's simply a state entity saying, you can't come here, and the sponsor of the bill actually provided an explanation or an example of that where someone had been restricted really unduly for quite some time. But this creates some framework.
Okay.
All
right.
There are recent comments I've read, and news coverage, I guess is the way we can describe it. Some critics of 2150, it allows a government agency, jump in when I'm wrong, to bar individuals, including journalists or concerned citizens, from public buildings if officials deem them confrontational. Is that trying to shut somebody off?
I could understand why the opponents of the bill, so if I want to look at this honestly and objectively, I can understand why the people opposed to the bill would have some real concerns. And I jokingly told the sponsor, you really should pick better bill titles. What the bill title says, an act to restrict people's access.
Yeah.
I'm like, let's work on that. She took it well. We joked about it.
Yeah.
So I could see people's concern. And honestly, the feedback that we received yesterday, from the state police, from Maine Policy Institute, was very quite helpful. And I think the current language of the bill does need to be amended. I question whether or not that this should be in the quote-unquote harassment statute, protection from harassment. And without getting too far into the weeds, the law courts have determined that a state entity can't be quote-unquote harassed, because the terminology in the harassment statute has to do with an individual, right? An individual is harmed, emotionally or mentally harmed, and a state entity can't be emotionally and mentally harmed. So I think that we needed a different avenue or a certain exemption to that. So the feedback that we received is actually really helpful. And that, when you look at legislating in general, rarely is the language that's put in or submitted for consideration ever the language that comes out of committee and is voted on. That's the reason we have the committee process. And the people that support an idea and oppose an idea, if people are actually listening to each other, that's when good policy is made. Those discussions we had yesterday were really good policy discussions that I think are going to push us towards threading the needle where we're ensuring that taxpayers are not being bullied by state entities, which right now they currently are, and being restricted. But we also have to ensure that members that work in those agencies aren't, being threatened or potentially harmed.
That couldn't be said much better, Ms. Henderson. We thank her for that. Now, in addition to this recent bill, folks, that's proposed by the majority of the Democrats, of course, because they have the majority and they have had it for, I think, the last several or 2 terms of Janet Mills. Not only having just the one, of course, Republican on this co-sponsor of this bill, but it's not even fair, folks. Not even fair at all. So we want to get on to another one, another organization that we've subscribed to for many, many years. And we believe you know who he is. The minute we put his face up here and everything is Jay Sekulow, who is the president and founder of the American Center for Law and Justice. Put him there a little bit more on center. There we are. Because the potential for fairness, folks, before we get to Mr. Sekulow here, bears another observation by yours truly here. Mark Merrill with Firm, as we're talking about Maine Legislative Bill LD-2150 versus you, the Maine citizens. As far as the status of the bill, we just had a public hearing on it. The public hearing, to get back to the beginning here, folks, was back on January the 30th, January 29th. And, of course, the members of the Judiciary Committee held a public hearing that morning. Now, as far as things going on beyond that, they still have work sessions to do on it. And also, there's going to be, I'm sure, more public input on it. Like I said, we'll certainly stay on top of it to make sure that you know what's going on. As far as your freedoms and rights, we're looking for anything that's a red flag, as we mentioned, or something that could be a potential threat to our way of life. Not only in Maine, but the entire country, folks. Keep us in mind right up here, too, while you're at it. FairnessInReportingMedia@gmail.com, FairnessInReportingMedia@gmail.com, 24 hours a day, 7 days a week. Here's the other observations, folks, that we found out from LD-2150 under a search called What is the Status of Maine LD-2150 on Copilot. So we've already gone through the title again, folks, but just one more time. I know, bear with us. It's an act to establish procedures for restricting access to state property, access to state services and communication with or through state entities, by Democratic Senator Nicole Grohosky and several other Democratic and independent co-sponsors, including the one Republican who you just heard from, Rachel Henderson of Rumford. Now, supporters argue, including Ms. Grohosky, that the measure is intended to address harassment of government officials or entities and to provide a process for safety and order in public institutions. Opponents, including the Maine Policy Institute and others, warn it could undermine the First Amendment. No kidding. Really? Due process of law and free speech by allowing broad subjective enforcement of harassment terms like intimidation or fear without pre-deprivation judicial review. Well, I'm sorry. You know what? We got to stop here, folks. This is damn stupid and ridiculous. That's right. You heard it from me. Owner, founder, Mark Merrill of FIRM, Fairness in Reporting Media. You're full of it, deflectocrats. Absolutely full of it. You're all Republican, Democrat, Independent, Green Party, I don't care who you are. You're elected to public office because those are the risks you take by being, guess what, a public servant. You don't like it, then you get out of the fire. You don't try to pass foolishness like this LD-2150 just to get your way. Afraid you'll be offended with, what does it say here? Opponents say it could undermine the First Amendment and free speech by allowing broad subjective enforcement of harassment terms like intimidation or fear without pre-deprivation judicial review. Where the heck came up with that? And what the hell does it mean? On the latest updates, LD-2150 had passed both the House and Senate, was reported to have become law. However, hold on, ding, 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 ding. Some news outlets note it still faces debate and potential hurdles before final adoption. Given the conflicting testimony and constitutional concerns, its final status may depend on post-enactment review or further legislative action. The most current official status can be checked out on the Maine legislature's bill tracking page for LD-2150, as it may have been amended or placed on hold after enactment. Careful what you wish for, deflectocrats. Stop whining. You swore an oath to uphold the law of the Constitution, so help you God. Got that? As for our friend Mr. Seculo here, folks, he sent us a notice that just had to be at least held on to for specific issues such as free speech, which they deal with on a regular basis. And we welcome his input all the time. He's a regular contributor to our organization, and on occasion, such as a podcast like this on Maine Bill LD-2150, quoting from him on December 15th, 2025. Voices for Freedom matching challenge deadline is almost upon them. That was before the end of the year, just passed. Censorship doesn't happen by accident, he says. The radical left desperately wants to shut you up and shut you down. Two cases in point. Big tech companies working in tandem with pro-abortion activists and government officials have created a coordinated system of discrimination designed to suppress your Christian views and any speech that's pro-life. The ACLJ has uncovered evidence of censorship by Google, Microsoft, TikTok, and other platforms that hides pregnancy resource centers in online searches while promoting abortion centers. It's downright despicable and utterly unconstitutional, just like this bill proposes. In conclusion, the ACLJ legal team will get to the bottom of it, and starting with letters to the United States House Judiciary Committee Chairman Jim Jordan and Lieutenant Governor Dan Patrick, chairperson of the new White House Religious Liberty Commission, demanding federal intervention to end this anti-Christian bias. Thank you, Mr. Seculo. In the meantime, folks, as always, our organization is all about truth, facts, reality, and common sense. Let's stick up for our flag, the Constitution, the Bill of Rights. Especially our young people, as you can see here, hoisting the flag. It's all about the future, especially with our 250th anniversary upcoming in July. Pray for guidance and for calmer heads to prevail, folks, as well as honest, straightforward, and calm and cool and collected debate about maybe some adjustments to this bill, or maybe ought not to pass at all. Stay safe, everyone, and peace to all.